So earlier this week, you had the Illinois Supreme Court hold oral arguments in the Macon County challenge against Illinois' gun and magazine ban brought by State Representative Dan Caulkins. But of course, leading up to that oral argument, there was a lot of question as to judicial integrity with a couple of the Supreme Court justices on the bench that received $1 million each to their campaign coffers from Governor J.B. Pritzker, and even these two Supreme Court justices also getting six-figure donations to their campaign coffers from Illinois House Speaker Chris Welch. Both Welch and Pritzker main defendants in the challenge against Illinois' gun and magazine ban. So this is a question of, judicial integrity, and we've talked about this for quite some time about, just the cloud of conflicts of interest. Even if it's not if it's even assumed, it could still damage the judiciary and the public's respect for the judiciary. So that's one reason why it was brought forward, and not just brought forward by bloggers, not just brought forward by questions from media to the governor, who said it's ridiculous to think that there is a conflict because he gave $1 million to then Supreme Court justice candidates who ended up winning in 2020 and are now on the bench. It was also brought forward officially by Jerry Stocks. He's the attorney for Dan Caulkins, and he motioned that the two justices, Elizabeth Rochford and Mary O'Brien, recuse themselves. He also asked the Supreme Court entirely to block these two justices from hearing the case. That was an official motion with the Illinois Supreme Court, and the two justices and the court denied that motion. So the case went forward, and all 7 justices were on the bench, including Mary O'Brien, including Elizabeth Rochford. And earlier this week, Elizabeth Rochford, she ended up asking questions of Jerry Stocks during the hearing on challenging Illinois' gun and magazine ban.
The special legislation clause prohibits an arbitrary classification. And in this case, the classification is based on the training of the exempt individuals, and that they continue to maintain that training while they maintain their exempt status, as opposed to just everyone else. Is that an arbitrary?
It is arbitrary because consider this. A military veteran is trained, but he can't have that weapon to protect his family at home. A security guard may or may not be trained, but he has it only while he works. Heller and McDonald both say the Second Amendment elevates above all interests. It's not tolerating interest for a police officer, interest for a security guard, interest for a prison warden, interest for whatever, or here, the most glaring offense, for the grandfathered. There is no reason to conclude, but on an arbitrary basis, that the grandfathered are any better trained or safer than those that would acquire the weapon later on.
So again, that's Jerry Stocks responding to a question from Elizabeth Rochford, the same justice that denied a motion from Stocks to recuse herself because she took a $1 million campaign contribution to her campaign fund from Governor J.B. Pritzker, and also a six-figure contribution from House Speaker Chris Welch, both of which who are main defendants in this case. After the hearing earlier this week outside the Illinois Supreme Court, I asked Jerry Stocks, despite them denying the motion for recusal, is there something further you can do with that concern that he had? He says that he still has that concern, and yeah, there's some things that can still happen, though he wouldn't be clear saying that he can take this to the U.S. Supreme Court. Here's the Q&A I had with Jerry Stocks after the Illinois Supreme Court hearing earlier this week.
It just comes with it.
You had a motion for 2 of the justices to recuse themselves denied. In a statement, you said that you're going to focus on the merits, and if there's a potential remedy down the road, we shall see, or something to that effect. Yeah. Where can you go from here if they rule against you?
First, we have to see what the ruling is, and I have to respect the process and the decisions that govern that decision they made. But that was called a Caperton challenge, And Caperton says that a court of review must accord due process in the context of freedom from bias or prejudice on an issue, our motion in form, or the appearance of it. And Caperton, as a U.S. Supreme Court case, requires that to be an objective test. And so we personally feel that the orders that came back were subjective tests that imposed a burden of proving actual bias or prejudice. We would disagree with that, but it may not ultimately manifest in any impact in the case. That really cannot be measured until we see how the ruling is, and if the ruling is adverse, then we just have to measure and evaluate that at that time. I remain and stand behind the issues raised in that motion because I submit that it is the prudent course for our judiciary to be highly guarded on those issues. And I recognize that they got to be careful not to disqualify themselves out of every case. I mean, it's a tough call. And Illinois politics makes it really tough on judges because they have to be elected in this state. So I recognize those issues, but my personal view as a downstater is it's pretty darn corrupt in Illinois, and I know our perception downstate is that we want to see that the process and the institutions, not aspersions on the individuals, but that the institutions and our procedures do more to protect against that.
Could you take this to the federal courts, the U.S. Supreme Court?
We will evaluate those issues. I would say that the Caperton issues remain under consideration and viable.
And that's the Caperton is referring to
the
campaign contributions.
There are other components to that. It's not just the money. It's a threefold matter. It's from whom it came, being the other branches of government, and the independence and separation of powers concern. 2, the amount, and 3, the reported pledge. We didn't say. We don't know what they said to the Political Action Committee. We know only what the Political Action Committee advertised they said. And they may, they had an opportunity and they deserved an opportunity to address that issue, and they expressed it, and I will accept that they were sincere in what they expressed, and that's what good judges would do.
So again, that's Jerry Stocks after the Illinois Supreme Court hearing earlier this week, talking about the questions that still remain about judicial integrity when it comes to 2 Supreme Court justices when they were candidates, taking $1 million each from Governor J.B. Pritzker and 6-figure donations to their campaign funds from House Speaker Emanuel Chris Welch, when Welch and Pritzker are main defendants in this case, in this challenge. So I don't think we've heard the last word on there. And I think another issue that is part of this overall question about judicial integrity deals with the Judicial Inquiry Board. That's a board here in Illinois that fields complaints about judicial misconduct, conflicts of interest. From my understanding, there has been a filing to the Judicial Inquiry Board on this very issue. Has it been taken up? A lot of times with these things, you can't necessarily see the progress of these allegations that could be made through the Judicial Inquiry Board, for instance. Begs the question on if we need to have some Freedom of Information Act requests capabilities for the Judicial Inquiry Board. But this is obviously something that is been filed to the JIB, and anybody can file a complaint to the JIB, including attorneys that have questions about misconduct or conflicts of interest. So can this particular issue of conflicts of interest go to the U.S. Supreme Court eventually? Again, another avenue in this entire saga that we'll continue to monitor and track for you each and every morning here on WMAY. It is Springfield's Morning News. You can always call in live and local at 217-629-7970. Again, 217-629-7970. Got to take a break, though. 6:50 from Culver's West on Wabash.
Work with a team that cares about